Karis North, Murphy Hess, Tomey, and Lehan LLP discuss 40B development process.
Sorry, I'm just going to have Allison come up, so if there's any questions, she's here.
Actually, Anne just wants to remove herself from the attorney as much as possible.
You never know when you may become a target.
That's right.
Well,
I understand.
we've asked Attorney North to come in to explain the 40B so that everybody understands it, the do's, the don'ts, that type of stuff. And afterwards, like Mr. Archinsky wanted, we'll give the people who want to speak on it, I'll ask, who they are, and we'll do that after. So after you go through your spiel, the board will ask questions, and then we'll open it up.
Sure, thank you.
Welcome.
Good evening.
Good evening.
So I'm here to talk a little bit about the background and the process on 40B. And I just want to say to start that I'm going to talk about generalities. There's no specific application pending or available to review or provide specific analysis on. I also want to give you a little bit of my own qualifications. I've been an attorney at Murphy Hesse for 17 years, and I've been practicing law for almost 25 years now in the municipal field in land use and environmental law. I am the 40B expert at our firm. I represent many communities, either as through our town council relationships or as special counsel hired specifically for 40B projects to provide advice on behalf of cities and towns. I have worked on small projects, I have worked on large complicated projects, I have worked on projects that have sailed through, and I have worked on projects that have gone through litigation. So I have a fair amount of experience. I've worked with many of the big names in 40B representing developers, including Mark Bobrowski and John Smolnick and many other folks, and have good relationships with all of the council on the other side. And I think that's one of the important pieces to being a good advocate for the town, is to be able to develop those relationships so you can have frank conversations when you're in the middle of a 40B process. What is 40B? So forgive me if I'm giving you overly general information, but I want to sort of take it from the top down. So 40B refers to Chapter 40B, Sections 20 to 23 of the Massachusetts General Laws, which is the comprehensive permit law. The law was established in 1969 by the General Court to have a consolidated local review and approval process for these houses, these projects that are focused on creating additional affordable housing in the Commonwealth, because the General Court decided as a matter of policy that it was important to make more affordable housing available. It does, in many ways, override local control, because it steps in and overrides local zoning laws and other local bylaws. So you do lose some of your local control, but again, that was a policy decision made by the General Court. That applies if there's you also still have other state law that apply. So for example, the Conservation Commission would review the project under the Wetlands Protection Act, not under the local bylaw, and also building law and the building code and public safety law also still applies here. That doesn't get overrided. So there are some exceptions where, the way 40B works is that if a community doesn't meet one of the statutory minima, which are statutorily described minimum standards for affordable housing in the Commonwealth, then that affordable housing becomes the overriding need. Those statutory minima are things like having 10% of your housing as affordable, and I believe Drake is around 5.5% right now. And also having 1.5% of your land area devoted to affordable housing, and that's the analysis that Ann referenced earlier that is going forward. There are some other safe harbors that are created by DHCD's regulations, and Allison and I have talked about whether or not they apply to Dracut. Some of those are very application specific, so we can't complete an analysis until an application is provided. And so we're still in the process of evaluating whether or not any of these safe harbor apply, and that's the first step when you are considering or facing some 40B applications. If safe harbor apply, then there's one process. If safe harbor doesn't apply, then there's another process. The eligibility for safe harbor is determined as of the date the 40B application is filed with the town clerk, so it's a snapshot in time. So once that application is filed, whatever your safe harbor status is, it is, and you can't change it going forward. So who issues a 40B permit? You know, becoming familiar with your Dracut zoning bylaws, and you have multiple boards that have authority under land use, but under the general laws of the Commonwealth, only the zoning board has the authority to issue a 40B permit. It is not the role of the select board, the planning board, the town administrator, the town manager is here, or anybody else in town to make the decision and issue the permit. Now, input can and should be sought from other local boards and commissions, and in fact, one of the first things that happens after a 40B application is received is that application is submitted to all other relevant local boards and commissions for their review and input, which they then submit to the zoning board to consider as they're reviewing that application. And then obviously there are public hearings that happen and have to be opened fairly quickly after an application is received, where you can get local and community input. How does a 40B application come to the town? Well, the first thing is the applicant has to get a project eligibility determination. And you are all likely familiar with the fact that there is a particular project that is seeking project eligibility. And Allison provided a response on behalf of the town that I thought was very comprehensive and detailed. And so project eligibility requires that the applicant not only submit a bunch of information, including, you know, site location and descriptions, maps, conceptual site plans, some pro forma information, evidence of site control, and the proposed waivers that it's seeking for local and other zoning bylaws. So that has to happen first. No applicant can actually apply for a 40B until they have that project eligibility from the subsidizing agency. So that's the first step. Once an applicant does have that project eligibility, then they may file their 40B application, which is a fairly complex application, again, because it's a comprehensive permit application, and it does supersede and override local zoning. So there's a lot of information that has to be provided, including a copy of the project eligibility, determination. I've been talking all afternoon and my mouth is getting dry. Existing conditions plans, preliminary site development plans, preliminary scaled architectural drawings, the inventory of proposed buildings, a preliminary subdivision plan, utilities plan, and then the requested waivers from the zoning and other local bylaws. So after an application is filed, the application is sent, again, for this preliminary internal review to ensure completeness, and also is sent to the local boards, offices, and commissions, like the Concom, Planning, Board of Health, Public Safety, your Affordable Housing Trust, if you have one, DPW, a Design Review Board if you have one, your Water and Sewer Commissioners, and possibly others, depending on the location of the project. The ZBA has to open a public hearing for the project within 30 days of receipt of a completed application. And then, thank you so much. And then, subject to extensions, which have to be agreed upon by the applicant, the ZBA has 180 days to complete its review of the project and close the public hearing. That may be extended in writing, and often is in a cooperative process. But if not, then the ZBA has to close that hearing and then must issue its decision within 40 days after the close of the public hearing. Excuse me. Failure to close the hearing or issue the decision in a timely manner can result in an automatic approval of the application as submitted. So that's something you really, really don't want to have happen, and is something that council and Allison and the zoning board will absolutely stay on top of. What kind of assistance is available to towns in reviewing a 40B application? So there's technical assistance available, including peer reviewers. And again, specific to each application, the zoning board will determine if peer review is required. Typically, it's required for things like stormwater and environmental issues, site engineering, traffic issues, and other design issues. And then the reasonable costs of the peer review are borne by the developer under 4453G. So a 4453G account is opened, the developer puts some money in that account, and that's used to pay the bills of the peer reviewers, subject to approval of the zoning board. DHCD also provides technical assistance in the form of consultants, and Allison and I have already started talking about what consultants may be appropriate for the town to have help from the DHCD, and then legal assistance is also obviously available. So once a public hearing opens, what happens? Well, it's like other public hearings. The ZBA hears the testimony from the applicant and then all the other interested parties. It reviews the application, it hears from the peer reviewers, it makes factual findings, and then it discusses revisions to the application or the plans with the applicant. And all of these discussions have to happen in the public hearing. There is often additional discussion that might happen between community development or the town manager and the applicant about particular community needs. And you know, it's important to be able to have conversations about what Dracut might need from a project in terms of size, scope, location, mitigation fees, and things like that. All important conversations to be thinking about and related to the impacts that the project may have on a particular community. Can the ZBA condition a 40B permit? Yes. The conditions have to be reasonable, and there is case law from the SJC that talks about how the conditions can't make a project uneconomic for a developer. So you can't say have an application for 150 units and only approve 50 units. That's likely going to be uneconomic for the developer, and it is unlikely that such a permit condition would ultimately be upheld by the reviewing bodies. So there are some limitations on the conditions, but again, this is an area where there is usually a fair amount of give and take and conversation between the applicant and the community through council or through other means, and often in the public meetings themselves. Once conditions have been agreed upon, then a permit is drafted, usually by council working with the developers council, and specific issues will go to the ZBA for resolution if they can't be agreed upon, all in the context of the time frame, the peer reviews, and other issues that have come up. And then once a permit is, once a public hearing is closed, there is 40 days to issue that permit. The negotiation of the language of the permit tends to take a while, so I usually recommend that the public hearing remain open in case there are any issues that need to go back to the ZBA while you're working on the language of a permit. And then once that permit is ready to be voted on by the ZBA, close the hearing, vote on the permit. It gets filed with the town clerk, and there are 20 days to file an appeal. And depending on who files an appeal, whether it's abutters, whether it's the applicant, whether it's the town itself, or another board on the town, it depends on whether the the appeal goes to the Housing Appeals Committee or to Superior Court. And I have litigated cases in both the Housing Appeals Committee and the Superior Court on behalf of communities challenging permits or defending permits that were being challenged, both sides of the case. So that's the general big picture overview. Happy to answer any questions. I guess I should ask Allison first if she has anything else to add that.
No, I think that's a great overview. You know, at this point, as Kara said, we don't have anything that's been before us, that's come before the ZBA, so, you know, once we receive a project, that would be when we would start really delving into details. So at this point, we're kind of reviewing concepts and scheduling some trainings and getting ready.
A couple things that jumped out to me is, number one is we don't have a submittal, so we don't know, we can't put a cost factor on it as far as the impact of the town.
Correct, not yet.
Not yet. I mean, I think from discussion earlier, he put in the maximum, which would be 300. It can appeal over 300, is that correct?
Over 300 may trigger one of a potential safe harbor. So 300 is the largest number that likely would be able to be constructed without triggering a safe harbor provision, yes.
So, yeah, realistically, so he put that in, but that's probably not what's gonna end up being, who knows? But
Yeah, we don't know.
No,
We can only
that's-
speculate.
Everything is the unknown right now. The board have any questions?
I have a couple.
Go ahead.
Go ahead, Jen.
You had said 10% and 1.5% of the land, or is it or?
It's or,
Okay.
yes.
alright.
It's 10%
Or-
of your housing or 1.5% of the general land area.
Okay. And you said that the public safety law still applies. Can you give us an example of what that would entail?
Access roads for fire trucks, things like that. So sprinklers, smoke detectors in units, things, that's what I mean by public safety provisions.
And is there anything for the impact of the town? Because some of these projects are just going to, we're already at max capacity for our schools. Is there anything in there about
That's something that you have
town
to.
resources?
Yeah, there isn't, and in fact, the case law, it really tends to skew towards, if it's a municipal service, the community has to provide it. But that's where you really have to have a conversation with the applicant, and you have to see what kind of, discussion you can have in terms of what I would call mitigation fees. And where you might be able to agree to, some financial concessions or size concessions, to have a project that really fits the town better than perhaps what has, initially been proposed. So, that's, other than, the only other way to do that is to have what's called a LIP project, a local initiative project, where that's what's called a friendly 40B, where the select board signs an agreement with the developer in advance of submitting a project eligibility letter and in advance of submitting a report, an application, where they've agreed to some type of payment structure in advance of the project going forward. So, but there's nothing in the law that says a town gets X amount of money for hosting this project.
Okay.
Tony?
I guess I'll start.
Sure.
First of all, I'm very happy to hear that we put out, whatever it is that you're doing with that 1.5 land use thing, because I've heard a lot of different things about that. Have you ever heard of a revenge 40B?
Sure. I think sometimes when applicants don't get what they want in terms of a more discretionary permit, they have said, oh, I'm going to file a 40B. Same thing where they might decide to build a Dover protected type of project as well.
And so, in this negotiation, what do you do if the builder doesn't want to negotiate? What do you do if the builder says, I tried for a normal development, and I couldn't get it, so I'll show you. How do you negotiate that? And I guess the second part of the question is who do you get your direction from when you're negotiating?
So because the zoning board is the board to whom has the permitting authority, they're the board that I typically have worked with, but they're usually on the same page with the town and the town's interests. So the town administrator, town manager, chair of the select board will usually be involved in sort of the upper level discussions about what it is that the town is trying to accomplish through this project. Remembering at the end of the day, it's the zoning board that does have the actual authority to issue the permit. So obviously you want to work with as broad a swath of the community, the town, as possible. And as a lawyer for the town, you are representing the corporate entity of the town, right? So you have to sort of work through that, regardless of who you are. With respect to the negotiations of the Revenge 40B, I think that first of all, you can't force somebody to negotiate, and if they're not going to negotiate, you have to have a strategy about how you're going to handle the project if they're not going to negotiate. And you have to know, you have got to have done your homework. You need to know what is best for the community. You have to know where you are, obviously, with respect to the statutory minima, because if you're going to assert a statutory minima, you have to assert that defense to the application 15 days after the public hearing is open. So that's no later than 45 days after the application has been filed. So you have to have that work done in advance, and you need to know where you're going to be in advance. So you've got to do your homework, you've got to have a strategy, you've got to be able to articulate that to the zoning board, and then you're going to have to guide the zoning board through the process. And they're going to decide what they're going to accept and what they're not going to accept. And I think that you may have to be ready for the fact that an applicant may not like where the zoning board lands. And you're doing what's right for the town. But I'll be honest. It's a hard lift to challenge a permit from the community side, right? So there's not a lot of legal framework on which there's some, but not a ton. So you really have to know and have experience doing it. I've litigated, in fact, asserting the 1.5% defense for a community, and we came as close as you possibly could, and we really should have won, and we didn't win. The HAC found that the community I was litigating for was at 1.47%. It is a number that will be engraved on my tombstone, because I spent that much time and energy fighting that case, and it was really disappointing. And unfortunately, that happens. And as I said in my earlier discussion, you lose some local control here, and it's a challenge. And you really have to sort of figure out from the community what your strategy is going to be and how you're going to make this the best outcome for the community, understanding the regulatory and legal framework that you're working in.
So you've talked about public input, and we have a couple of hundred people that are ready for public input in some of the projects that are coming forward. But what about governmental input? I mean, as a selectman, and I see something that causes me great concern, either because of public safety issues and things like that. I mean, do we get to opine on that? Does the zoning board get to opine on that other than their vote? Do other people, the community development director, is the state looking for governmental input as well as public input?
Yes, absolutely. So as I said, one of the first things that happens once the application is received is it goes out to the relevant public boards, commissions, offices, and asks for input that is delivered to the zoning board, which they will take into account when they ultimately issue their decision or ask questions of the applicant or ask the applicant to modify the project. And that will also be looked at by the peer review agencies as well.
Right, I guess one of my concerns is that, we don't get a lot of these, we have a lot in the pipeline right now, so I wonder if, they can be considered, I mean, how can you look at one 40B project and completely ignore that 3 more are coming down the pike? And how do you articulate the impact that all of them together are going to have on the town?
Yep, and that's a great question, and that's a question that has been asked by many other communities. And it's a question that, to a certain extent, is addressed in the regulations. If you have a certain number of projects of a certain size over a certain period of time, you may be eligible for one of those regulatory safe harbors. But you have to have, more information than I can tell you today. But there is some consideration of that. That's also something that you articulate in your comments on the project eligibility letter that I think Allison did articulate
Yes,
fairly
yep,
well.
yep.
But at the end of the day, if you don't meet, if you don't qualify for those safe harbors, the regulations are pretty clear. You look at each project individually, even though you want to look at those cumulative impacts as of the date of the application that is filed. So you have to look at a project on, March 1st, and if another one is filed on March 5th, the one that, you can only look at that as of March 5th, and the one that was filed on March 1st hasn't been built, permits been granted. So even though you have 2 in the pipeline, you have to still look at them separately. And I've been there with communities as well, where we had 2 and, litigated the 1.5 on both of them, and then agreed that we'd stay one while we'd stay the second one while the first one, went out, and we'd abide by that decision. That's different, again, if you're not asserting a safe harbor. So unfortunately, your own internal analysis is still going to have to take into account those impacts.
Okay, I'm happy to hear, though, that, that other public officials, can opine on individual projects, because I don't think they know that. I don't even think we know as a board that we could say, hey, this is not good for our town, or there are true public safety concerns that need to be mitigated before you get my vote. That's for sure. So I'm happy to hear that there's going to be governmental input as well.
Absolutely, it is definitely part of the process.
Thank you. Got anything?
Sure. Are there grounds for which the ZBA could reject a 40B if we haven't met the 10% or the 1.5%? And if yes, is there a penalty imposed upon us from the state?
Very few grounds, and they are likely to be litigated. And so there's no penalty imposed, but you'll pay for the litigation, and the chances of success depend on what the grounds are, but there are very few cases out there where communities denying applications have been successful. So not a lot to work with, but there is some.
Okay. In the impact fees, that's, if we say there's a public safety issue regarding the access roads, and we know it's going to cost $1 million to fix the road or build it up, is that a negotiation with the builder on the impact fees, or can we just impose and say it's going to cost this much, you owe this portion, or do they not owe anything?
Yeah, so the first way to attack it is, if that's part of the project, then that's on them.
Okay.
And so if it's an access road that the fire chief says is required, for public safety reasons, then they have to build it, and the zoning board, would likely require that as a condition of the permit, depending on, maybe it's an access road and we want you to do this as well, that might be a negotiation. Again, it's going to be very fact specific.
Okay. Tony already asked my question about current projects.
That's all right.
A question about the 1.5% land area. So it's general land area, does it look at, it only looks at buildable land?
Pretty much, yes. It exempts certain kinds of protected land. It exempts all state and town-owned land. It exempts roadways, it exempts water bodies, and things like that.
Okay. I was trying to back into the number of acres we have in a 21.36 square mile radius.
Not counting the water.
Yeah,
I don't
not
know that
counting the
number,
water.
so I-
And DHCD, actually, since the case I litigated, DHCD has issued guidelines very specific to how you actually calculate it, which they really took from what we learned in my litigation. And they require what they did, which is too bad, they require an all GIS analysis. We actually used surveyors and went out on the land. I had a surveyor work with me, and we walked that land. And they actually prefer GIS, which is less accurate than the surveys. But that's what they decided to do. So that's why you having a consultant do it.
Would have any more questions?
I have one more, for Allison. So the firm that we've hired, they know this is the way to do it as opposed to a survey with the GIS?
Yep. We got 3 different bids, and this particular firm has just completed this for another community of similar size with similar, kind of raw data, if you will, in terms of affordable housing areas and that kind of thing. So they've just been through the process, and they're gonna go through it again.
So this is not project specific, this is just something that we should know anyway, relative to
So
the 1.5?
it's kind of both. It's a useful information to have. Like Karis had said with other things, it ultimately needs to be pinpointed to the day an application comes in. But, that's it. It's not a number that's gonna shift from today to tomorrow. So at this point, we'll do that calculation, and we may be in the ballpark at 1.47. We may be so far away that it, kind of we check it off and move on.
Does public housing count towards affordable housing?
It depends on how it's subsidized. It's pretty specific. The guidelines, the DHCD guidelines tell you what kind of public housing counts and what kind of public housing doesn't, and it's all based on the subsidy. So some does, some doesn't, and I can point you to the page in the guidelines if you're interested. With respect to the 1.5%, it's a useful planning tool, and it also helps you figure out, for example, if the town wanted to acquire more land to, change the numerator in that calculation to make it more favorable for you in the future, that's something you can figure out, and you can use, you can use that calculation to figure out what you might need to do, how much more affordable housing you might need to have to sort of get you to a place where you could find a safe harbor too.
The other piece with that, the formula and the computation, is that it doesn't automatically count an entire parcel just because there's affordable housing on it. So if it's, a significant portion of the parcel is still wooded or something like that, that's not gonna necessarily count while you're trying to figure it out on the back
We
of the
get
envelope.
right down to the
there, Heather.
nitty gritty, huh?
They did
It's
do.
an
Yeah.
incredibly detailed,
very specific
analysis.
sidewalks
Yeah.
and impervious surfaces, related directly to the housing, because back in the day, there was a community that built affordable housing and then had huge open space around it, but it was all owned by, the affordable housing entity, and that all counted, and DHCD realized that really wasn't putting more units in, and so they changed the regulations in 2008, I think, to take that into account.
Just one more thing, Counselor. So you did say that there have been some cases that the appeal has been upheld by the HAC, or the towns have won, or the
course.
municipality has won.
I can count them on one hand.
Okay, can you do me a favor? Can you send us a couple of copies of that, just so that we can see
Sure.
what a successful
Yep.
project looks like? And are you aware that there are municipalities that have, are in the process of suing the HAC, the Housing Appeals
I'm not aware of any, I mean, there might be, you know, I follow decisions, I don't know what's necessarily pending, I haven't taken a look at their website in a while, but,
Okay.
there may be, and I'm happy to take a look and see what's, they don't hear a lot of cases, I'd say they hear between 5 and 10 cases a year, so not a lot,
Really?
yeah.
Oh, okay.
Would they be sued by the town, or would they be sued by the,
Well, it depends on, it would be at the HAC if the developer brought the claim or the abutter brought the claim. If the town brings the claim, it goes to Superior Court. So it depends on who brings the claim.
I have one more question, if I may. I'm not sure if this is true or not, but we were told at a separate meeting that local towns of Tingsboro and Tewksbury made their minimum eligibility by something called inclusionary zoning.
Yes.
Could you talk to us just a little bit about that?
Sure. I don't know whether the underlying fact is true, but inclusionary zoning requires, would be a change to a zoning bylaw that requires, if you're building, if you're permitting a project in Dracut that's, 10 units, you may say for every unit over 10, you have to put in, 10% affordable units rounded to the nearest unit. So you can create affordable housing in projects in your community by changes to your zoning bylaw, and create the different standards. And there are a variety of inclusionary zoning bylaws out there, and I'm pretty sure DHCD has a model inclusionary zoning bylaw, or maybe it's the Planners Association. One of them has a sample inclusionary zoning bylaw, and I work with a couple communities that do have inclusionary zoning bylaws in their own communities, and that has helped them stay above the 10%.
Allison, is that
Yep.
part of our bylaw review
So-
right now?
At this point, the only inclusionary zoning elements that we have are in our overlay areas, so the mill overlay in particular. It is one of the topics that the Affordable Housing Partnership is talking about to weigh in on to the zoning bylaw rewrite committee. And to that end, probably 3 weeks ago, we had a Saturday morning housing workshop over at the library, and folks came in and we talked about housing density, affordable housing, areas of town where it might make sense to see more density or to preserve a lack of density, areas where not only in terms of the density, but also in terms of the housing style that community members felt would be appropriate for Dracut. Do you want 150 unit apartment building, or do you want triplexes, or, kind of trying to align in the eyes of the community where and what that development could look like. So once we get that report back from NIMCOG, then we'll start to look at whether inclusionary zoning makes sense. One of the cautions that they put forth at NIMCOG when we talk about it is that if we were to have, for example, any unit count over 10 would require 10% affordable, we might suddenly see an influx of 9 unit developments. So, we need to do it all, craft it with some thought, but it is on the table.
And Allison, that's all part of our housing plan? Or that would be all part of our housing plan? Do we have a housing plan?
We have a housing plan, and the housing plan talks about what we need as a community. It doesn't necessarily talk about a recommended way to get there. So that's part of, taking the information in the housing production plan, in the master plan, the seminar that we just did, the authority, or the partnership will meet next week and start that conversation around what's the best way to get there to meet these goals we have.
is it for the board?
I might have one more.
It's okay, no problem.
From the time the permit is submitted to the zoning board, who then negotiates? Is it just the zoning board that looks at the application and decides 300 units is too much for this reason, or who handles the negotiation between the contractor and the ZBA?
So typically, in my experience, it's been counsel for the town, or special counsel has been the negotiator with the counsel for the applicant, subject to direction from, as we talked about earlier, the ZBA and sort of a conversation as to what's right for the town, because you're representing the town.
Thank you.
I will ask, how many people out there would like to speak or ask questions? Come up and give your name, Dana, and...
Give your name, Dana.
Yeah, name, Dana. And also, before I begin, she's not gonna answer hypothetical questions, she's just gonna be able to go on what the law says.
We'll see where it leads us. So, if I follow you rightly, the snapshot of when the project is filed, that is when you determine whether or not the town meets its 1.5%?
Correct.
And so that, right now, that number's relatively unknown, yet to be determined. Is there a circumstance in which case the town might achieve a push in that they would be able to meet a minimum change in affordable housing in order that they would not be required to fulfill the application this year, but might then have to address it the following year? If we were able to change it, I think the number that I was told was 0.03 change in any one given year, that it would buy us time.
So that's one of the, I think what you're referring to is one of the regulatory safe harbor standards.
Yes.
And again, that's very project-specific.
Okay.
And very town-specific, and Allison and I have, looked at some of those numbers. We'll go back and double-check them as well. But, as of right now, I think our preliminary indications are that
Unlikely to be met?
unlikely to be met.
Okay, thank
Yep.
you. And as this particular project that we seem to be addressing, it sits right on
There's no
the...
project that's been filed.
Correct. It sits right on a town boundary, and it is the concern of the neighboring town almost as much, it seems to be, as it is ours. Although that may be hard to imagine, I kind of get that sense. Does the abutting town have any way to address their concerns, even if the project is being filed in our town?
They have the rights of an abutter, just like a neighbor. That's really it. They don't have any
So on
higher
the string,
rights.
they're way out there, because they're not even a resident. So
Yeah, but they do use the same roadways.
that's my point. I mean, that's one of their larger concerns.
Yeah.
But is it a direct abutter?
Well, it depends. It's usually within a distance, so they may have rights as an abutter.
Okay.
And obviously, anybody can come in and speak at a public meeting, anybody can raise concerns, and if their roadway concerns ultimately affect the Dracut roadway, then maybe your traffic, a peer review of the traffic would take that into account or not. I'm not a traffic engineer, but that's certainly an issue that would probably be raised by any traffic peer review.
Yeah, I think, and I don't know if Allison would agree, but we'd probably make the effort to meet with them to see what their concerns are at some point.
Okay. I probably have a lot more to ask, but I thank you for your time.
You're welcome.
Is there anybody else that wanted to speak? Go ahead.
My name is Linda Hayes. I have a question about the financial health of any developer who submits a 40B project. So if we're looking at a project, particularly in many cases, these projects are long-term, they're not immediate. Is there any place in the process to determine whether the applicant is truly able to make the financial commitment, specifically when there's no state or federal funding involved in the actual construction of the project?
So the applicant has to submit a preliminary pro forma financial statement to DHCD, or the subsidizing agency, when it applies for its project eligibility letter, and they make determinations as to the financial health or suitability of the project. But that's really the only place, until after the project is permitted. The town, that's an issue that's reserved for the subsidizing agency and is not the province of the town to really comment on.
So in the comprehensive permit process, the ZBA doesn't have any authority to require developers to submit bonds or certain kinds of financial commitments that would protect the community?
That's different, and
Okay.
there may be some bonding requirements for roadway completion, sidewalk completion, other sort of standard land use type bonding requirements. Yes, those could absolutely be part of a decision with conditions.
Okay. And speaking with regard to the other community that abuts this project, it's a very kind of unique situation where the road that would lead to a project actually has a boundary that runs down the middle of the road, and the road is shared with another community. So there can't be, I would assume, changes made to that road unless you only made them on one side without working with the other community. So what rights does another community have with regard to saying, well, this is a public safety issue for us regarding trying to expand roads in order to provide access?
Again, same rights as an abutter, and that issue about the road would be looked at in a traffic analysis,
Okay, and could,
which would include public safety issues.
but could it include public safety issues for the abutter as well? In other words.
Well, I think by definition it would, based
Okay.
on how you've described the road.
So if another community has a shared road, then the other community has the right to address issues of public safety that would affect their residents, even as well as Draycott's residents.
As an abutter only. They don't have any higher threshold of right.
Okay. And I don't know what that means
It-
legally.
Yeah,
you know.
I mean, it means they have the right to comment and inform the zoning board of their comments, and then they have any rights, again, depending on distances and where the town boundary lines are, which I don't know, to bring a challenge to a permit at the end of the day.
And-
So they could participate in the process like any other abutter.
Okay.
But their regulatory boards cannot.
Right, but they're
Okay.
correct. Thank you for
So,
completing that thought.
could you then clarify what you meant by a challenge and what legal rights any abutter would have to challenge?
I really am not going to comment on anybody's legal rights. Every abutter has a right to bring a challenge to a permit, at least on the face. Going beyond that, I can't comment. It's far too speculative.
Okay, so you have a right to, they have a right to a legal challenge. Where does the legal challenge go? Court? That kind of a legal challenge?
Yes, that's what I mean. It either goes to the Housing Appeals Committee or Superior Court, depending on who challenges what.
Okay, so abutters do have that right, and as a community with abutter rights, the neighboring community would have that right to challenge it in court.
Most likely.
Okay, thank you.
You're welcome.
Anybody else? Okay. Well, thank you for coming in. I think it was very informative. I think we all understand the 40B a little bit better.
Great.
And
And I will,
I think it sounds like you're up to the challenge.
thank you.
So I just want to highlight too that on our project webpage is this, which is a guidebook handbook for 40B. It's intended for zoning boards of appeal, but it kind of outlines the process step by step in phases. It's very useful for abutters, interested parties, board members. So it's on our webpage.
Great, that's great.
It also has in it a very useful single-page handout on page 16 that lays out all the various timeframes and
Everyone
steps that I think is useful, and that I actually pulled out to share with you all. So I will look for some examples of successful challenges to send over to you, and then I agree with Allison, take a look at that handbook, and I'll also send you this single page. I think it'll be useful to have.
Thank you.
Great, thank you, Council.
You're welcome.